I'm Suzanne Rabb, and I'm a barrister at Serle Court Chambers. I'm here to discuss LIBOR transition and managing competition risk. The market transition away from LIBOR towards a successor rate or risk-free rate as early as 2021 has left a number of unresolved legal questions. Over the last decade, there have been a number of competition and regulatory investigations into the manipulation of benchmarks such as LIBOR. And it seems as though even with the market move away from those rates, there may still be competition issues to consider. LIBOR has been the subject of many investigations ever since 2012, when the US Futures Trading Commission issued a penalty notice to Barclays for manipulation of LIBOR. And since then, many of the world's financial institutions have been subject to similar investigations. Recently, a publication by the Financial Law Committee has highlighted a number of risks with the move away from LIBOR to a successor rate. And it's noted that although competition issues may be beyond its remit, EU and UK competition law may still be relevant. The financial sector itself has been subject to a number of investigations, principally under the rules on restrictive agreements contained in Article 101 of the treaty. At EU level, the European Commission has focused on interest rate derivatives. One of the reasons why competition or antitrust regulators have traditionally been alert to this area is the potential use of benchmarks or indices to fuel actual or potential collusion amongst competitors. But if a trader has no interest in the benchmark, perhaps because they don't trade in the underlying problem, in principle, competition law should not be a concern. But competition issues do arise where the parties do have an interest in the outcome of a particular application of a benchmark, and there they may have an incentive to manipulate it. But even if a trader knows that a trade will have this or that impact, in the absence of market power and the fact that they are unilaterally determining the outcome shouldn't be a concern. And they may even decide to act through parallel incentives to net off their position to avoid an adverse impact. The problem arises, though, where having visibility over those different movements and the underlying rate, there can be an incentive to collude on market outcomes. Important areas have been highlighted by investigations, and these include the appropriate balance between criminal penalties and civil penalties. There are also evidential issues. There's a lot of bravado in the trading room. How much can we really discern from that? Is this just about bravado, puffery, about asserting a strong position? Or is it really indicative of an intent to collude? There's also a question about double jeopardy, as many investigations are pursued worldwide into very similar practices. There's also a consideration about whether this is an appropriate area for intervention by regulators or competition authorities. In the UK in particular, the Financial Conduct Authority has got both regulatory powers and concurrent competition powers. And it's hoped that with the increasing experience of the UK's FCA in this area, that will lead to a much more targeted and appropriate deployment of regulatory as well as competition law tools in this area. Meanwhile, this is an area that will continue to tax the compliance functions of the leading financial institutions.